All right, well, it's 5:30. Can you hear me okay, Mr. Krupinski in Zoom land? We'll just check that first.
Okay, I had it muted just so you guys didn't have to hear me rustling around. How are you today?
Pretty well, thanks. No problem. We just wanted to check that anyway before we got into it. So,
Okay.
yeah, we'll go ahead and get started. So, good evening, everyone. So my name is Ryan Collins. I'm the chair of the board of the City of Bangor's Assessment Review. Our hearing this evening is to consider the appeal of GNS Associates of Biddeford, LLC, through its agent, Mr. Krupinski, concerning the denial of its abatement request for property located generally at 323 Stillwater Avenue, Bangor, Maine, designated as tax map R56, lot 014, and by the city as account number 9129. So we follow a standard format for our hearings, for our proceedings. So we will proceed then generally as follows. Starting as chair with a statement of some of the issues before us this evening and kind of an outline so we can stay organized. We'll move to an opening statement by the petitioner, should the petitioner like to make one, followed by petitioner witnesses, the petitioner's witnesses, and pre-filed exhibits and any additional exhibits I would like to have admitted. We'll move into the same for the respondent, so an opening statement should they like to make one. We'll move into a presentation of witnesses and then go over pre-filed exhibits and then add any additional exhibits to the record. From there, we'll move to a rebuttal from the petitioner, followed by a rebuttal from the respondent. Then we'll move into argument by the petitioner and then by the respondent. Finally, we will conclude this evening with deliberation and a decision of this board at the end of this meeting. So I will note here that after any of the witnesses have made a presentation to the board members, as well as the other party, may ask questions of that particular witness. So we're not really a formal court proceeding, we're more of an administrative proceeding, but we will have an opportunity anyway for some back and forth. The following board members are in attendance tonight. Myself, Ryan Collins is chair. Mr. Dean Beaupain is here. He is the vice chair. And regular member, Mr. George Burgoyne, is in attendance this evening. I will mention this does constitute a quorum of our board where there are 3 or more regular members in attendance. Are there any immediate objections to the composition of this panel by either the petitioner or the respondent?
None.
Mr. Krupinski?
No, I just wanted to make sure. So we're gonna go right to this at 5:30. I think originally it was scheduled for 7. So is this the only item on the agenda? And it's fine. I'm ready to go.
Yeah, I appreciate that. The scheduling letter that I had, we had you down for 5:30. There is another one tonight.
Okay.
It's like at 7.
Okay.
But yeah, we would if
That works for me.
you're able, and apologize for the confusion. We'll proceed. So, okay. Well, with that, then I will mention also that the hearing tonight, of course, is being recorded. So for that reason, we can only have one person speaking at a time. We obviously have the respondent or the petitioner rather in Zoom format. So we need to just pay attention to what's going on Zoom. For our Zoom participant, obviously, please turn on your microphone when speaking and then ideally mute it when finished, just so we don't get background noise or feedback.
Okay, that's fine.
Appreciate it. Just as a preliminary matter, I do want to ask Mr. Drew, behalf of the city, have taxes required by Title 36, Section 843 point or decimal 4 been paid so that we can proceed this evening?
Yes, they've been paid in full for.
They're paid in full. Okay, thank you very much. We'll proceed. Okay, so the questions then before the board this evening are really threefold or twofold. We want to know if the subject property that I identified was substantially overvalued as of April 1st, 2023 or not? And then if so, if we decide it is overvalued, then what is the just or appropriate value of that property as of that date that I specified? So our presentations, our evidence will kind of keep on that track. I will mention also, but any evidence this evening which has reasonable probative value will be admissible. Anything that's immaterial, irrelevant, potentially something that's unduly repetitious will be excluded, or it's unnecessary. I mentioned prior, but there are no technical rules of evidence for this proceeding. However, there is a requirement for due process, which is why we have all the pre-filed material in front of us. All that being said, are there any immediate or preliminary matters which either party would like for the board to address or deal with before we get into the presentations? Mr. Krupinski, do you have anything immediate outside of the prior question?
I do not.
Sure. And the respondent, anything?
I do not.
Nothing. Okay. At this time then, the petitioner, Mr. Krupinski, would you please identify any witnesses that you may offer this evening so that they may be sworn?
I will be the only person that'll be speaking this evening.
Okay, sure. Mr. Drew, likewise, would you please identify any witnesses so that they may be sworn?
Just myself.
Okay, perfect. Well then, would each of you then this evening please raise your right hand and answer me truly. Perfect. Do each of you solemnly swear or affirm that the testimony which you are about to give in this matter now before in hearing shall be the truth, the whole truth, and nothing but the truth under the penalties of perjury?
I do.
Thank you. Please, perfect. Please be seated. Okay. We will proceed with the presentation of the petitioner. Again, general format would be an opening statement should you like to make one. You're the only witness, so you would then kind of get into your presentation, your exhibits that you filed, and anything else that you'd like for us to consider.
Okay. So good evening. I'd like to first introduce myself to the board as well as Mr. Drew. Mr. Drew and I have had quite a bit of correspondence, mostly setting up this. So I do appreciate his time and effort on that. So my name is Paul Krupinski. I'm a senior tax manager with Commercial Property Tax Management. One of our clients that we represent is Harbor Companies. They're the owner and investor, mostly from what we have worked on in various states in the Northeast, are multifamily properties and communities. And that takes us to the property that we're here to discuss, which is the Willows located at 323 Stillwater Avenue in Bangor. It's parcel R56-14. So after reviewing this, which we do pretty much on an annual basis for our client, we had determined that we were of the opinion that this property was overvalued. We filed a petition to the city, and at that time, when we did file the petition, I believe that what we included with our petition and the indicated value that we had filed on the petition was $1,577,000, was an income approach to value along with the rent roll. And I also believe it was the income and expense statement was also included. And if not, there was a summary of that. Our application was then denied by the city. Or I think I should, let me just step back for a second. Prior to it being denied, Mr. Drew had sent out a questionnaire asking for, or I should say, he had conveyed that he did not believe that us as petitioners had stated a proper case and did not prove that the property was overvalued. And at that time, he asked for a variety of information. And I apologize. I just have a couple piles right in front of me, and I'm just trying to. I only have the desks that I work on most of the time, rather than kind of a large table. And I just needed to, just so you know, I'm not totally fumbling through it, but I was just trying to find what I was looking for. It's actually on my right side.
Yeah, we have a few minutes, not a problem.
Okay. So at that time, and this was as of a certified mail, a letter that was dated January 31st of 24 from Mr. Drew. He had asked us to submit the following information: copy of any and all appraisals done on the property, now subject to your appeal over the past 2 years, copy of rent rolls as of April 1st of 22 and April 1st of 23, any service agreements in place for the subject, audited financial statements for calendar year 21 and 22, and any other information that we felt was pertinent to the value of the property. So we did do that. And then I believe on March 20th of 24, we then received another letter from Mr. Drew stating that he still did not believe that we had shown any type of case that the property was or should be valued at $1,577,700, and that pretty much any information that we submitted, based on what I had at least perceived from the letter, it didn't even appear to me that anything that was submitted by us, which of course came from the taxpayer and the owner of the property, was even considered. So at that time, we then filed an appeal to the board, and as and just so the board does understand, I was not aware of the appraisal at any time until after Mr. Drew had sent us the letter I had just kind of summarized, asking for an appraisal. The appraisal was, and this then kind of formed the basis of the value that we appealed to the board. The appraisal was completed by O'Connell Valuation Services. The effective date of value was January 3rd of 2022, and it was done for financing purposes, not for the purposes of the appeal. And at that time, the value actually of the appraisal was less than the value that I had originally submitted in our abatement application, and the value of conclusion of the appraisal is $1,390,000. And I believe for the board, that is the only actual document that we've submitted in regard to this appeal.
Okay, thank you. I'm just going to get caught up here, and then did that conclude your presentation, Mr. Krupinski, or is there other items? I wasn't sure if you were shuffling or not.
No, I think that, sorry about that. I think that that concludes our initial presentation, correct?
Okay, thank you. So at this point, then, the board typically, would we have questions at this point for the petitioner? Oh, sorry, I'm skipping ahead. So the respondent, then at this point, would you have questions that you'd like to address to Mr. Krupinski on anything?
Do you want me to have my opening?
Now, do you have any questions over his presentation that you want to ask him?
I don't think that's his whole presentation. I think that's just his open.
Oh, is that just the open?
That is pretty much my opening, correct?
Okay, well, then, no problem. So,
I wasn't sure, does Mr. Drew now have an opportunity to kind of present anything, or is it just questions from?
so yeah, typically at this point then, and I missed admittedly that was the opening. You would continue then through your, through the presentation of any other materials that you would have submitted or any other statements that you'd like for us to.
Okay, so just to,
Keep rolling.
okay, so one other part that I'd like to kind of bring up is one of the common themes that, I guess has been, I believe in each correspondence from Mr. Drew and the city, is that by providing the income approach to value, that we haven't, I guess, provided enough evidence to show that the property was grossly overvalued. This is an older property that, and the reason that I'm using the appraisal, and this is in agreement with the owner of the property, or Ken Redford, who I believe is the CEO or president of Harbor Companies, is that the appraisal and an appraiser that actually did this went on in her appraisal to explain why only the income approach to value was used to derive her indicated value. The sales comparison approach, and on the appraisal, it would be, I believe, on page 11. So she kind of talks about her valuation analysis. And so, of course, as we know, there's three approaches to value: the cost approach, sales comparison approach, and income approach. And she kind of goes in to explain why the cost approach was not completed, as the age of the improvements make the depreciation difficult to accurately measure. I mean, I can read the entire thing, and then also the sales comparison approach was not completed, as leased properties like the subject are purchased for their cash flow and income characteristics by investors. Therefore, any adjustments would be income-based and would not enhance the reliability of the analysis in this report. And then the income approach was completed, as the subject is an income-producing property and there's adequate data to develop a value estimate with this approach. So a couple points going back to our initial abatement application all the way through what we submitted to the board being this appraisal, is some of the finer points that were made, I guess, in, as I said prior, in recognition that Mr. Drew was not of the belief that we had shown any type of gross overvaluation, is, I mean, this is an older multifamily subsidized property. Using the cost approach wouldn't be reliable. No investor and no value would ever be, based on what I know, and I have been, my career spans back to somewhere around let's say 91, 92, first as an appraiser. And then I've also been a tax consultant and also an in-house property tax manager for a major retailer. So, goes back well over 30 years. Any property like this, if you're trying to determine market value, is not going to be valued based on a cost approach, not going to be valued on a sales comparison approach. What I've mostly received from the city was sales of comparable properties located in the city, both subsidized and market rent apartment complexes. And when looking at this, I think the income is how any investor would look at market value. I've just never personally seen where, if there's no basis for the other two approaches to value to be used, why would they be used? So as I said, I think that, and then secondly, the other part is my original income analysis that I provided that had the 1,577,000. What I really did, and I do this quite a bit in my practice for other properties, other asset classes, is I initially looked at the actual income and expenses for the year in question. I believe I added back in the taxes and then had a loaded cap rate, and that indicated a value of $1,577,000. What I was told by Mr. Drew is that using the actuals wasn't appropriate for the appeal, as well as to derive market value of the subject for assessment purposes. So the appraiser, she actually did use market factors, and she came up with a value that was almost $200,000 less. So I felt that by using the appraisal would be the most appropriate measure for what the market value is for the subject, rather than my analysis. And that's why we submitted the appraisal to the board as the basis of our appeal. So, for the most part, that would then conclude my presentation at this point. And just so the board understands why there was kind of two values, a decreasing value from the original petition to when we did file with the board, and why we submitted the appraisal and the appraisal only as an indicator of value rather than the original information that would have had the income analysis of rent roll and the income and expense statement.
Okay, no, that's helpful, thank you. So at this point then, you'd indicated that concluded your presentation. Yep, you're welcome. We would move then to questions from the respondent for Mr. Kropinski. Yeah, please use the mic.
Good evening, Bill Drew, City Assessor. I've worked in the assessing department since 1993, and I was appointed the assessor in 2015. Thank you for having this hearing tonight. Paul, nice to formally meet you.
Yes, nice to meet you as well.
Yeah. Yes, and as Paul laid out, we're here to hear the appeal on a 41-unit apartment complex located off of Stillwater Avenue. And Paul did kind of summarize some of the early correspondence that we had. One of the letters Paul described was really the 706A request letter, which is usually sent out to a taxpayer when an appeal is filed. And that's usually an opportunity to ask for additional information from the taxpayer. And we did so. And so tonight we're really here to determine whether the assessment was manifestly wrong. So manifestly wrong is a two-part test. One,
Mr. Chairman,
Mr. Vice Chairman, you have the floor.
is the assessor cross-examining or making his presentation?
Great question. We're after any questions about Mr. Kropinski's testimony currently, Mr. Drew, and then we would move to your presentation.
yep, I was just gonna have a question right after that.
Okay,
Yeah.
nope, got it. We weren't sure if we were tracking, that's all.
No,
So,
only,
thank you.
so manifestly wrong in the state of Maine is what the law court has told us that we have to consider. It's a two-part test. One is, can somebody show that the property is significantly overvalued? And the second part of that test is, how is the subject property taxed and the amount of the tax? And how does that relate to other similar properties in the city? So it's not just a single part test, it's a two-part test. And I think one of my early letters to Paul was to ask if any kind of tax analysis had been completed to show. So I'm asking you, Paul, tonight, did either you or the appraiser produce any type of tax analysis to show that the subject property was inequitably assessed?
I do not believe that either. Well, I know that I did not, and I don't believe that the appraiser did either. As I said, the appraisal was not done for assessment or tax purposes.
So my next question would be, so for an appraisal to be completed for ad valorem purposes, the statute 701A requires that the appraiser consider the three approaches to value and to develop two of the approaches. So was this appraisal done for ad valorem purposes or for bank refinancing purposes?
It was actually, is that the question? It was actually done for bank refinancing purposes.
Okay. Those are the only two questions I have at this moment.
Okay, thank you
Can I
very much.
elaborate on that or no? Can I only respond to the question?
I think, given the circumstance, I think we could entertain a brief clarification or elaboration. So
Okay.
please.
So, and this is not, it's just based on some experience, especially over the past, I don't know, let's say 4 to 5 years. One of the things that I have found with assessors asking for appraisals, pretty much across the board, is, of course, most appraisals are done for some form of refinancing or portfolio management purposes, and kind of runs the gamut. I do all different types of asset classes of properties, and some smaller than this and some larger. And I think pretty much across the board, almost every appraisal that has been requested by an assessor, I don't like to say 100% because I want to make sure that I cover myself because there could be one out there. But most appraisals that have been probably completed for refinancing purposes in the last 5 or 6 years have been greater than any assessed value that I have seen, or greater than a value that we have submitted as being what we believe the proper value should be for assessment purposes. This one kind of went against that trend, and it's the first appraisal, as I said, that in my knowledge that was done for refinancing purposes that was not only less than, well, I shouldn't always say less than the assessment, but less than the market value for assessment purposes, as well as less than any value that I had asked for. And so I guess, I could understand why it wouldn't be considered. But if it wasn't going to be considered at all by the city, why would the 706A ask for it, number one? And I believe, as I said previously, the appraiser did consider the other approaches to value, but she kind of invalidated them because either of them wouldn't have any, for the most part, they just would not provide any indication of value for a property that would be traded truly for its income that it generates.
Okay, thank you. Okay, well, at this point, while you're there, Mr. Drew, are there immediate objections to any of the pre-filed exhibits that Mr. Kropinski has provided on behalf of the petitioner?
I guess just a reservation would be that the fact that the appraiser that completed the work isn't here tonight to answer any questions that you have regarding that work.
Okay. So noted, anyway. Are there immediate objections from the board to any of the pre-filed exhibits from the petitioner? Okay, well, seeing none, and again, so noting the appraiser isn't present, we'll then admit the petitioner's Exhibit 1, which consists of Mr. Kropinski's letter, which was dated May 10th of this year, the petition, the agent's authorization for him to act, the appraisal completed by Catherine O'Connell, who is apparently a certified appraiser, again, understanding she's not present, and then her resume. So we will add those for consideration. Mr. Papinski, are there other materials that you'd like to enter for the board to consider tonight beyond what's in front of us, or just what we have currently?
I think I'd like to just kind of stay with what we have. I think, I kind of read into the record some prior correspondence, but I don't think it's necessary
Yeah.
to
Perfect.
submit.
Okay, so we'll be considering then the packet, as we'd indicated, dated May 10th.
Yeah.
At this time then, we will move to the presentation of the respondent, which again generally includes some sort of an opening, should you like to make one, witnesses, which is yourself, and then we'll move into that sort of questions from the petitioner and or the board. So Mr. Drew and the respondent, floor is yours.
Thank you very much. And yes, we're here for the Willows. And for this property, it is a rent-restricted apartment complex. This GNS, if I can shorten the name, acquired the complex from Maine State Housing Authority, I believe after a foreclosure some years ago. And they've held it all this time and managed it well, and really in support of the taxpayer's case. They do have the one opinion by the appraiser in the appraisal report. I just want to note that it was completed in January of 2022, which was really 15 months prior to the valuation date of April 1st, 2023. And I'm sure over that time, market conditions changed. But I would just like to start with the rule. So 701A, as I mentioned earlier, really requires the assessors to, in one section, consider the effect upon value of any enforceable restrictions impacting the property, directs us to consider functional obsolescence and economic obsolescence, and obviously the just value of the land arises from and is attributed to the legally permissible uses. And then it does go on to say, where it was modified a couple of years ago, in determining just value consistent with the Maine Constitution, a property subject to restrictions, contractual or otherwise, that restrict the permitted use of a property may not be considered comparable to property not so restricted. So it's a little bit different in this case because when that was added, it was to prevent, if you had an unrestricted property, as far as rents, going out and finding an unrestricted property, going out and finding a comp that's restricted. They're just saying that they're different. And I think through my presentation, I will show that we have met that condition of treating rent restricted value and unrestricted differently, and substantially differently. So again, this is a 41 unit complex, and it's really 71 of the 41 units that are rent restricted. And just quoting from the appraisal, at this time, the owners of the property are not maximizing the potential market rent, nor the Maine State Housing established rent level for the restricted units. So I would say that they've not been keeping up with the adjustments that they could make to increase their income. And the one thing that we rely upon for the restrictions, so they are recorded in the Penobscot County Registry of Deeds in book 65057, page 131. And those restrictions, it's a good one because there's a qualified period, and the statement says that the restrictions end on the expiration of the useful life of the development. So we would expect that this owner and any future owner, as long as it's an apartment complex, is going to have to abide by these restrictions. And I've attached it, exhibit page 1 and 2. Here I've just attached the affordable main housing options that are in Penobscot County, and that report on exhibit page 2 shows the Willows halfway down the page as rent restricted units. So that information is available to the public. So the city agrees that the property's highest and best use is as a multifamily complex, encumbered with those restrictions that are recorded. And the main impact of this, the restrictions really limits the property's net operating income versus properties not so restricted. So the city's valuation approach, the city's principal valuation approach for commercial properties is the cost approach to value. And it's been that approach since before 1993. It has served the city very well. The important part of the cost approach is to accurately consider depreciation, functional obsolescence, and economic obsolescence. And when you do so for mass appraisal purposes, it is a reliable approach to use. So within the city's valuation model, we have a place to put an economic factor, and that will affect the property value either up or down. So for the city, an economic factor above 1 indicates that the city's cost approach to value estimated was adjusted up. So if the market tends to indicate a higher value than our cost approach, then we're going to make an adjustment in our economic factor and have it be above 1. For this property, due to the subject property's restrictions, the economic factor used in the valuation calculation is 0.8. And this is as seen on the attached valuation report. So if you look at exhibit page 4, which is the city's valuation printout on page 4. Pretty much on the lower left here, it says economic factor 0.8, and then there also in the right-hand section, economic factor of 0.8. So that's really just showing you that it's in the assessment record. So what I wanted to do is show you and provide to you other multi-residence apartments without rent restrictions. And the 3 comparables that I grabbed were all within 700 feet of the subject property. And they would be experiencing similar market forces. So table 1, we have 3 multi-unit projects, apartment complexes. And they're also shown on the map below. And we want to just look at what the economic factor is For an unrestricted apartment complex with 40 units, the top one, 321 Stillwater Avenue, that economic factor is 1.25. The second one down, 300 Stillwater Avenue, which is just southwest of the subject property, 32 units. Their economic factor is 1.3. And on the corner of Howard and Stillwater Avenue is an 8 unit, so their economic factor is 1.47. So really, when the city chose to use an economic factor, that's what resulted in our value of like 1.9 million. Had the city deemed this property equal to apartment complexes that had no restrictions, we probably would have had an economic factor near 1.25, similar to 321 Stillwater Avenue. Now, if we used that factor, the resulting value would have been over 2.8 million, or approximately 50% higher than the April 1st, 2023 assessed value. And starting on exhibit page 8, that's an example of the valuation report modified with a factor of 1.25 versus 0.8. So we can see that the city's valuation model made a significant adjustment for being rent restricted. Now, if we look at table 2, and we look at the assessed values for those same 3 complexes, 321 Stillwater Avenue had a per unit value of 61,000. 300 Stillwater Avenue had a value per unit of 48,600. And then 397 Howard Street had a value of 83,275 per unit. Now, our subject property at its current assessed value only has a value of 46,600 per unit. Significantly below 2 of them, and even below 300 Stillwater Avenue, which happens to be 32 one-bedroom units. The subject property has 40 two-bedroom units and just one-bedroom unit. So to still be below 300 Stillwater Avenue means that you've made a considerable adjustment. Now, the next part is just a comparison of other rent-restricted units in the city. So when we look at table 3, now we're just trying to see, is the city treating the Willows like other rent-restricted properties in the city? And if we look at table 3, we've got the name of the apartment complex, location, map and lot, and the economic factors used for those properties. So the Waterworks is a 35-unit structure, and that has an economic factor of 0.76. The Heights, 32 units, has an economic factor of 0.75. Freeze's Building, 35 units, has a factor of 0.78. And again, all these properties are also listed on Maine Housing's affordable housing chart that I gave earlier, indicating rent restricted units. Now, if we take a look at the assessed values of those properties per unit, Waterworks, 45,794. The Heights on Boyd Street, 58,875. And the Freeze Building downtown, 60,194. And again, to remind you, the assessed value 46,600, and the petitioner is seeking a per unit value of 33,900, considerably below. So I would say that The standard valuation approach that we've employed in the city is the cost approach. We have applied depreciation based upon its age and condition. We've considered functional obsolescence, but there hasn't been any for this property. And for the economic obsolescence, we've made an adjustment from what typical market conditions would be down considerably. And I would just say on the petitioner's valuation approach for that appraisal, again, the intended user of this appraisal is Bangor Savings Bank. It's not for ad valorem purposes. Had it been for ad valorem purposes, this appraiser would have gone to Title 36, Section 701A to help determine what needs to be completed for an appraisal for ad valorem tax purposes. Most appraisers that I know would not just for ad valorem purposes discount two approaches, but that appraiser isn't here tonight to ask. So I would say that the appraiser had said that the owners of the property are not maximizing the potential rent nor the main state housing establishment level for restricted units. And the owner's property manager reported that the rents that they are achieving are increased annually, between $20 and $25 per month. So just a very small annual adjustment at a time when inflation is pretty high, expenses are pretty high. So I think that's potentially one reason why they're here tonight. And the appraiser also recognizes that there's sometimes a higher operating cost management of these types of housing setups, and and they can't achieve the market level of NOI, and we recognize that. We don't think they would achieve it either. Therefore, we made our adjustments. The cost approach and sales comparison approaches were not completed, just the income approach. And to quote the appraiser, the scope of this appraisal did not include an analysis of the current tax burden on the subject in light of ad valorem taxation. So you don't have that piece from this independent appraiser to let you know whether the taxes on this property were equitably assessed or inequitably assessed. Really, in conclusion, so the process of correlation is required under Maine law. In Shawmut Inn case, to quote the law court, to correlate, an appraiser must calculate value by two or more appraisal methods and then weigh the factors used in arriving at each value to determine which method best reflects the market value. An appraiser must. In this case, nobody developed two opinions of value, and there was no correlation completed. And to say it again, the petitioner failed to provide an analysis showing inequitable apportionment. And out of one law court decision, it says the taxing authority must achieve a rough equality in treatment of similarly situated property owners. And I would say that we've done that for the rent-restricted apartment complexes in Bangor. And really, in closing, the city does not believe the petitioner has shown sufficient evidence that the assessment is manifestly wrong.
Okay. All right. Does that conclude your
It does.
presentation? Okay. Well, at this point then, thank you. We will move to questions from the petitioner at this point for the respondent. Mr. Kropinski, do you have anything? Yep. Hang on, I think you're muted.
Okay. I'm not muted now, correct? Sorry.
Good. Happens all the time.
It's getting late and I'm in my basement and I'm misconstruing unmute and mute on my screen. Sorry. Just the one question I have for Mr. Drew is, and he may not know this information off the bat. Is he aware if any of the taxpayers of the comparable properties that he had used, had any of them filed abatement applications for this year?
No.
Okay.
Thank you.
Thank you.
Okay. No other questions? Okay. We move then to the board. Would the board have questions for the respondent at this time?
No question.
Seeing none, okay. We'll move to Mr. Kropinski again. Are there any objections from your side to any of the pre-filed exhibits that were included in the city's packet, the city submission?
No objections.
Perfect. Okay, then we will admit the respondent, City's Exhibit 1, which consists of a cover letter, which was dated September 3rd, 2024, and its attached exhibits, which are pages 1 through 34. I see in here also there are a few copies of electronic mail messages, which were dated May the 29th, 2024, looks like July 10th, 2024. We also have a copy of the board's scheduling notice, which was dated August the 22nd, 2024. So we will admit those if the board has no objections. Cool. Okay, seeing none. We will continue on. We are at rebuttal or anything further from the petitioner at this time. So Mr. Kropinski, do you have anything further based on what's been provided?
So the only thing that I would like to kind of add to tonight with both presentations is that I do understand that the mass appraisal methodology employed by the city has served them well over the years. And I think that for the most part, for assessing in general, that mass appraisal, I mean, there's really many times no other way to do this. And I'm not on the side of the city, and I appreciate everything that they do. But sometimes when you have someone on my side, what we're looking at is from time to time, something stands out and something we look at with overvaluation. I'm not a tax consultant or representative that files a tremendous amount of appeals throughout each year. I only represent, I believe, 2 properties in the city, and one of them I don't believe I've ever personally filed on. It's a larger retail property. And so I think that while I respect Mr. Drew's presentation and the city's position, I think on the Willows specifically at this time, based upon both looking at the income generated by this, maybe they aren't increasing rents, which is probably a positive for everyone involved, including the tenants as well as the city itself. But at the same time, I think that the appraisal is indicative of what the value is. I did want to point out one thing that I was looking at, because Mr. Drew did point this out, and I would offer this as well for consideration by the board. Is I do respect the position that the appraisal was completed. I believe it was 13 or 15 months prior to the assessment date. And as we know, there have been changes in the marketplace. I was looking at the income and expenses that, while Mr. Drew was speaking to that point, that I had originally submitted to the city, as well as what was included in the appraisal. And they actually appear to be somewhat similar. One thing that was different was the cap rate that was used by the appraiser was 7%. The cap rate that was used by me, I guess you could say, hopefully I have the number of months, let's say 13 to 15 months later, I think it was 13 months, correct? Is I had used 6.5%. And I think that was for multifamily properties. That's based on, I try and look at surveys and come up with a reasonable capitalization rate. If I applied what was used in the appraisal to update that with the 6.5% versus 7%, the value I came up with was $1,496,200. So, roughly $1.5 million versus the $1,390,000. And it's just something I just wanted to at least throw out there for the board to consider. To not say that the market changed or may have had some changes, I think would be inappropriate and somewhat would lack any type of consideration by me. So that's
Sure.
kind of just one other thing that I wanted to at least point out. Other than that, before I just end, if this is the last that I get to speak, is I really do want to say that I might express my gratitude not only to Mr. Drew, but also the board, because it sounds as if you may have lost some members through a couple different reasons. And I appreciate it, because it truly is, I think, about a 4 to 4.5 hour one-way trip for me to drive. And so I really appreciate you accommodating me, as well as Mr. Drew working with me. I think that he probably had to work just as hard to get this hearing to take place as at least reviewing and considering the information that we submitted. So thank you very much. I do appreciate that.
Excellent. Well, no, thank you. It's a process, but I know we're largely here. We're volunteers, of course, because we want to be. So I appreciate it. Okay. So back to you, Mr. Drew, respondent. Do you have anything further for the board?
Just on the difference in the time frame from like January of 2022 versus April of 2023. In the assessing department, we analyze property sales each year and have had to make considerable adjustments to property values. And we actually produce a PowerPoint presentation that's available to the public online each year. So I just took a look at the PowerPoint that we produce for the value date of April 1st, 2023. So here we were reporting that multi-residence apartments had to go up at least 13%. Large, that was the average change. And then when we look at 2, 3, and 4 unit residence properties, they went up at least 21%. So the difference in a year back then was, quite considerable. So I think it is important to have a valuation opinion as of April 1st, 2023, because that's looking at the market conditions at that point. And then if an income approach is completed with market numbers, then it's looking out 1 year from that point. So I would just say, yes, we adjusted values throughout the city based upon increasing market values.
Am I allowed to add anything or no?
Sure, I think given the circumstances, we'll come back to you and then we'll come back to you.
So this-
Get your money's worth.
I'm trying. So just if that was the case, and I'll wrap it up, is if the appraisal that was completed in the prior time frame was 1,390,000 and the appreciation rate was about 13%, 1.13% times 1,390,000 is 1,570,000. And as I said, my original when filing the original income analysis with the abatement application was 1,577,000. So it just kind of takes things full circle. I don't like to think I'm that good, but very close to where that would be from my original abatement application. And as I said, I do think that it's an indication of market value, and that's all. I'm just adding that as an aside. But I do appreciate everything. So thank you.
Thank you. Back to you, Mr. Drew, for anything further. Where we went that way, so we'll go your way as well.
I am done.
Okay.
I've completed my.
With that, that concludes both sides' presentations and rebuttals and arguments. This would be the point then, typically as a board, that we would move into deliberate some of the material we got. But Mr. Vice Chair, you've got something.
Before we do deliberations,
Sure.
we have a procedural point.
Okay, let's deal with
Mr. Kropinski has been kind enough to extend the decision deadline to September 30th.
Yes, he has.
Today is September 26th.
Yeah, wow. That's gonna be tough.
And we've got two choices. One, if he would be kind enough to extend the decision deadline for another 10 days.
Sure.
We're required to issue a written decision within 10 days of making a decision, which presumably would be tonight.
Tonight, sure.
Otherwise, we are either going to have to
Pretty
stay
jammed up.
here and generate a written decision, or we're going to have to meet tomorrow because I'm going to be gone
Okay.
Monday and Tuesday.
So
Okay.
Let's. Oh, is that from the assessor? Okay.
Oh, no, that would be for you, Mr. Kropinski.
I'm amenable for whatever works for the board. There's nothing, I don't believe, unless Mr. Drew, he may know better, but there's no reason, whatever works for the board, if you're going to be away or whatever else, if you need 30 days, I have no issue with whatever's necessary
You could
with
just
regard to that.
email, I think you have the chairman's email address.
Yeah, in the city.
Just email him and say, I consent to extend your decision deadline to October 10th or whatever,
10,
some date in that area. And that will give us time. We have to meet again to approve a written decision.
Okay.
Okay?
No, that's helpful. Thank you. So we'll, just for summary here, procedural point or purpose, but the petitioner then agreed to extend the decision deadline approximately 10 days. So we have a little more time to, generate some kind of a decision, meet again, and then ratify or approve that decision. So
Okay.
thank you. And that being done, at this point then, let's typically move into deliberation among our board where we would discuss maybe key points or findings from either side. So I'll open this up. I guess technically I have the floor. One thing I'll point out as we move into this phase, but was the city's exhibit, specifically table 3. Now, looking at economic factors, it does appear to me anyway that the city did adjust this subject property for being restricted, of course, in rents, but specifically looking at the factors now, the economic factor, the 0.8 number appears reasonable to me if you look at 3 other subject properties with similar restrictions. I mean, I think we just have to remember, we're also evaluating sort of the reasonableness, the equitableness of the actions of the assessor. To me, that, looking at those comparable properties, 0.8 seems to be in the ballpark, anyway, from what I can see. One other thought, a little strange again, because I'm the chair, but I was talking, but anyway, would be that, looking at the appraisal now, that was submitted, by the petitioner, I think just in general terms, they sort of have a shelf life. They also often are done for a purpose or for a reason. And I think we'd heard tonight that, pretty roundly, this one was done for finance purposes and not necessarily for an assessment. I think in addition, there has to be some consideration or merit to changes to the prevailing economic conditions in market. So, we have the ability to assign weight and consideration and the like. I wouldn't look at an appraisal occurring, whatever, 13, however many months prior, and being done for the purpose of finance as having a lot of weight given the time frame. Anyway, I'll throw that out there. Well, Mr. Burgoyne?
The two words that stick in my head are manifestly wrong. I think that's a pretty high standard,
High bar, yeah.
and it's a very high bar. And the auditor's kind of dismissing, looking at the approach that was used. I think it took her 2 sentences to do that, or 3. And I like it. As you just said, it was the purpose of providing the information was to provide something that someone could use to get along, and really not other purposes. And I think it's real hard for something like that to show that the numbers are manifestly different, manifestly wrong. I think that's a real high standard.
Mr. Vice Chair?
From the perspective that it's the petitioner's burden of proof to show that the assessment is manifestly wrong, the appraisal is the wrong date and the wrong purpose and doesn't meet the standard required by Maine law, either under 701A or the Shawmut versus Kennebunk Court decision. So really can put almost no weight on the appraisal. Mr. Karpinski discussed at length an income approach he had prepared, but he is not apparently a Maine appraiser. He's apparently not a Maine CNA. We don't have a copy of whatever he produced, and it's a little tough to put a lot of weight on his approach to value when we don't have a copy of it, and we don't have input from the assessor on it. So I don't think the petitioner has met his burden of proof. I agree with George to show that the valuation by the city is manifestly wrong. The property on a per unit basis is very comparable to similar properties.
Yeah.
Much lower than market properties, as it should be, I'm sure. And also, when you look at how other properties are being taxed, the limitations of this project are reflected in the current assessment, I think.
Okay. Is that a motion?
No.
Okay.
This is a motion.
Okay.
I move to deny the request for abatement because the petitioner has not proven that the property was substantially overvalued as alleged in petitioner's property tax abatement appeal, and that there is not sufficient credible evidence to demonstrate that the assessment was manifestly wrong.
Great. Do we have a second?
I'll second that.
Okay, so it was moved and seconded that This board denied the request for the abatement because the petitioner has not proven that this property was substantially overvalued as alleged in the petitioner's property tax abatement appeal, and that there is not sufficient credible evidence to demonstrate that the assessment was manifestly wrong. Is there any further discussion? Seeing none, those on the board in favor of this motion, and I will vote or I'm here. Okay, well, the decision then is unanimous. The petition is denied by this board. We will prepare a written decision, which again, thank you for extending the deadline, but over the next 10 or so days, we'll get that out in writing. That will also include a copy to the city, to the respondent as well. So the purpose of our hearing being concluded at this time, then I'd entertain a motion to adjourn.
So moved.
Hang on.
I don't think we're gonna adjourn, we have another hearing.
Okay.
Before we,
Pump the brakes.
before we close,
I will not entertain that motion. Strike that.
before we close on this particular proceeding, I'd like to ask the assessor if he could check with the legal department and see if in lieu of having a second meeting and voting on the decision, can all three board members review the decision and sign it? And once all three have signed, that's the official written decision. And of course, any member in reviewing the decision thought it should be changed, then obviously we'd have a meeting to
At that
talk about
time,
that.
sure.
Okay.
Yep, I'm certainly in favor for that, and we can take that outside of tonight's proceeding, but that makes perfect sense to me and would be more flexible.
But we have to get the city attorney's office to tell us it's okay.
Yeah. Sure. Okay, well then, without adjourning then, I think we can conclude then this proceeding, and bid you good night, Mr.
Okay,
Kapinski.
thank you.
Thank you.
Appreciate it.
Certainly for your time.
Take care.
Take care.
Okay, take care. Have a good night.
You too.
See ya.
I have to figure out how to get out of here.
Say hello. See ya. Okay, let's maybe take a couple minutes anyway and kind of reset. I got papers everywhere, so let's
Okay.
do that. Maybe use the facilities and then maybe we can
Yeah, no,
get into the other
that's
one.
That's fine.
A little bit, I do see the petitioner is here. Thank you, gentlemen. That's a,
Before I start, anyway, you got me. Have you got anybody else on it?
Oh, my.
okay.
Excuse me. Bill, is this a restroom down? Right now?
Yeah, I think I'd like to do that
Right
too.
up straight, go, start going down the hallway.
And
Right on
then we
your right.
will proceed.
Yeah, I'm surprised a big firm like that, I mean, they must do work in Maine.
Yeah, I would
It's just,
assume.
you know, I'm not quite sure why they ran this up the flagpole, but it's
Sure
like,
either.
yeah.
Just seemed like, throw it and see what you get. But
I know, but manifestly wrong is
That's-
a real high standard, I mean.
that's a tough
legally,
one.
It's a real high standard.
Yeah,
It's not, well, we could fudge a little here and fudge
we
here.
can adjust this a little here.
Yeah, no adjusting.
If you read, I read a little bit of that case just to get a summary of it and get a handle on what was going on. And there were comments like you just made about that, the standard is like beyond provable. Yeah, basically you have to prove to an excusable right that it's wrong, basically. So it's, way up there.
Yeah, it's, yeah.
This is still live.
Oh, yeah, we were gonna take like 5 and maybe, visit facilities and the like, but that's fine, but Mr. Bopayne has stepped out.
Yes, we're short of a
And I'm-
member or two
Okay, well, we will, I guess reconvene, would be a term, because we've really adjourned, so, we're all set in Zoom land, okay. Well, good evening then. My name is Ryan Collins. I'm the chair of the city's Board of Assessment Review. We have a hearing this evening to consider the appeal of Fresh Start Incorporated concerning the denial of applications for exemption from property taxes for its several properties located in Bangor, Maine. And I'll pause here briefly. Do the petitioner or respondent have any objection to me not reading the rather long list of properties? Or would you prefer that I go
No
through it?
objection.
Doesn't matter.
No objection.
Perfect, okay. I will just mention public hearing, but the list of properties and accounts, will be printed obviously in the decision, so it will be there anyway. Thank you. So our hearing, our proceeding tonight, will proceed as follows. We use a standard outline. So I'm going over currently some of the issues that are before the board currently and the procedural matters. We'll move to an opening statement from the petitioner, should they like to make one, followed by the presentation of any witnesses and any accompanying exhibits. We'll move then to an opening statement from the respondent, if any, should they like to make one, followed by a presentation of any witnesses and their exhibits. We'll offer a chance for rebuttal from the petitioner and then the respondent. We'll move to argument then from the petitioner and the respondent. Finally, this evening, we'll conclude with deliberation and a decision by this board. I will mention that after each witness this evening makes a presentation, the board members and then the other party, the responding party, may ask questions of that witness. This evening, the following board members are present. Mr. George Burgoyne, Mr. Dean Beaupain, who's also our vice chair, and myself. I will mention, just for the record, that this does constitute a quorum of our board where there are 3 or more regular members present. From either the petitioner or respondent, are there any immediate objections to the composition of this panel? None? Okay. Thank you. I will mention this evening, our hearing or proceeding is being recorded. We're also, of course, live on Zoom. So that being said, I ask that only one person speak, obviously, at a time. And please approach the podium when you're addressing us, addressing the board, and turn on the microphone before you speak, just so that we can hear and those who attended via Zoom can. Then obviously turn that off when you finish speaking, just so we don't pick up crosstalk and room noise. Moving into some of the substance of tonight, I do want to ask as a preliminary matter, Mr. Drew and the city, has the petitioner paid all taxes required by Title 36, Section 843.4 or decimal 4, so that we can proceed with this hearing this evening?
They have.
They have. Okay, proceeding. All right, so the following questions then are before us this evening. Probably first and foremost, we need to decide if this board has jurisdiction to hear the denial of an application for exemption from taxation under Title 36, Maine Revised Statutes Annotated, Section 843. If we decide then the board has jurisdiction, then we need to determine if the applications for exemption were timely filed in accordance with Title 36, Maine Revised Statutes Annotated, Section 652L. If we decide then that the application for exemption was timely filed, we need to determine if Fresh Start Incorporated qualifies for a real estate as well as a personal tax exemption for each of its properties under Title 36, Maine Revised Statutes Annotated, Section 652.1 or decimal 1, A, 1B, 1C, and 1J. So evidence this evening, so all evidence having reasonable probative value will be admissible without the technical rules of evidence, however. This isn't a court, this is an administrative hearing. It is subject, however, to the rights of, or process, or due process, which is why we had pre-filed packets, of course. Anything that's immaterial, irrelevant, or unduly repetitious will be excluded where it's irrelevant for our consideration. The appeal that's been submitted is a little bit different, just for the board. We're being asked to reconsider our decision dated June 6, 2024, considering the prior appeal, which just for the board and those that may be joining, the meat and potatoes of the prior decision dealt with main law, looks like Title 36, Section 843. And at that time, we had determined that the board did not have jurisdiction, but that there were other avenues, it looks like at the time, the petitioner could proceed with. And one of those was an appeal. So there's that. Where this proceeding does directly track with and involve issues that we discussed previously, is there any objection to this board considering the record that was entered from the prior proceeding or from the prior appeal from the petitioner? Any issues with that? None?
No.
From the respondent? None? Okay. So we then as a board, we will consider the prior proceeding and the record of that prior hearing for this evening's consideration. That being said, are there any immediate or preliminary matters which either party would like the board to deal with at this time prior to the presentations? The petitioner or respondent? None. Okay. None. Okay, at this time, we will swear witnesses or anyone that will be offering testimony. So Mr. Party, would you please identify any of your witnesses or yourself?
Yep, my name is Scott Party, and I'm the president of Fresh Start, as well as whatever else I do.
All the other things.
Janitor, yeah.
Chief cook and bottle washer.
And I'm
All
the
right.
only person here on behalf of Fresh Start.
Okay, on behalf of the petitioner, okay. And then, Mr. Drew, the respondent, would you identify any witnesses so they may be sworn? Just
I'm the only witness, Phil Drew, city assessor.
perfect. Okay, at this time, please rise, raise your right hand, answer me truly. Do each of you solemnly swear or affirm that the testimony which you are about to give in the matter now in this proceeding shall be the truth, the whole truth, and nothing but the truth, under the penalties of perjury?
I do?
Beautiful, thank you. Please lower your hands and be seated. All right. So, as I'd identified in the preliminary statement of issues, I'd like to proceed concerning the first question, which is whether this board has the jurisdictional authority to hear a denial of an application for exemption from taxation under Title 36, Statutes Annotated, Section 843. I'll mention, as we move to each party's presentation, please address this issue directly, noting that the board's authority to act in an exemption denial was in question previously. Specifically, Section 843 states that jurisdiction deals with jurisdiction to the board over abatement denials. So we'd like to hear your positions essentially on this issue. We will move to the presentation at this time from the petitioner. Again, remembering to please address the jurisdictional question in 36-843. Mr. Party, floor is yours.
How do you turn it on? Just push the button? Oh, yeah, I think that works.
Dual green light, yep.
Yep, it's a green light. My name is Scott Party. I reside here in Bangor, and I'm going to address I didn't know I was going to be addressing whether the board has the authority, but I will address that. I do believe that after everything that we went through back in June, on June 6th, which is also my birthday, it was clear from all of you that were here that you did not have the jurisdiction to backdate stuff. And I agree with that. You know, you definitely you do not have the authority to backdate the jurisdiction of that previous denial. So, do you want me to move on to the next part?
I think we should just focus on the jurisdiction.
Sure. Yeah, I mean, I think at
That's
least,
the base question. I mean, if we don't have jurisdiction, then we don't have jurisdiction.
Well, you didn't over the date
Well,
issue.
what's changed?
What's changed is that I did exactly what you guys asked me to do, was wait for the tax bill and go another route, which is an abatement of the taxes.
But you didn't submit any valuation evidence.
I did not question the valuation of the property.
Well,
I know that Mr. Drew has approved that we are in fact exempt from property taxes for the next fiscal year.
Okay,
What I'm looking for is some tax mercy here.
but we're not the body to give it to you.
Okay, well,
Okay.
I'm just doing what I was directed to do.
I understand. But last time around, the board decided it did not have authority to hear exemption appeals.
Correct.
I understood from your paperwork that you were here tonight asking us to answer the same question.
This was not a repeat.
Well, do you want us to abate your taxes because you're exempt?
I want you, absolutely.
Okay, well, then we have to decide whether we have jurisdiction to hear that appeal.
Okay, so
And you just said that you agreed we don't.
I agreed that you didn't.
Oh, but we do now?
Well, with any luck.
Okay.
Would you like me to proceed a little
Well,
further?
no, if you have anything to add on the issue of jurisdiction, would like to hear it, then I think, Mr. Chairman, would like to hear it from the assessor. And then we need to consider and vote on whether we have jurisdiction to hear your appeal.
and I'll just add that I think part of this, and this is a little bit non-traditional, but I think, Mr. Party, your understanding of the prior hearing and maybe ours is slightly different in a sense that I believe, and I'm just tracking with the decision here simply because I approved it, I wrote it, in consultation with the vice chair. But a couple issues. One was, right, there isn't any way to backdate anything. There's no provision anywhere for that. The secondary issue in there was looking at the difference essentially between an exemption and an abatement. And the one thing, and Mr. Vice Chair, feel free to add to this, but one thing that came up, because again, we did consider the prior record, was that, there's a tangible difference between an exemption and an abatement. And the statute in question, it's silent, it doesn't say anything about this body having the ability to hear an appeal on an exemption, which is basically not that the value's wrong and I would like reduced valuation resulting in a lower tax bill. It's that we're not able to pay anything basically for taxes. And so I think the board's understanding anyway previously was that we were tracking towards an exemption and not an abatement.
Okay.
So that,
Yeah, can I just write here what it says here? Petitioner's remedy is either to A, file a complaint in Superior Court to review the decision of the assessor, or B, wait until the property is assessed for 24-25, and once the tax bills are issued, file an application for abatement. for each property, and if not satisfied by the assessor's decision, appeal that decision to this board. And that's what I understand we're here for.
No, that's not what you filed.
So, right, again, board's understanding and not at all trying to give anybody a hard time, just trying to make sure we're on the same sheet of music, was, this is the prior proceeding, was that our hearing dealt with the prior year's taxes. My understanding again from the prior proceeding was that the assessor's office, the solicitor, the like, had the appropriate paperwork. The reason that was included in the decision anyway was that they did receive the appropriate paperwork to apply that exemption for the following year's taxes. So that was not at issue at the time of the prior hearing. So we're trying to evaluate the prior year's taxes that your organization was found responsible for based on the date that the information was provided. If that,
No, that's clear as mud. I will say that, that when I was here in June, and it says right here, dated September 9th, after receiving all 7 tax bills for the 2025 President Scott Party delivered on blah, 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 abatement of the municipal property taxes, it says right here in this letter, which covered all 7 properties listed below, see City Exhibit 3-10.
Can I mention one thing? All exempt properties have an assessed value, and it is not zero.
Right, it's not 0.
Okay. So we have jurisdiction when the property owner thinks the value placed in their property is higher than it should be. In other words, the assessor has valued it too high. If you want to have that hearing tonight, we can have that hearing, but you have not submitted any evidence on the issue of valuation. And it's your burden of proof. And all we can do on each property is find, based on the evidence, that the assessed value of each property is too high, and then reduce it by the appropriate number, but it would never be to 0, okay? And then you have to pay tax on whatever the
Of course, I pay taxes, yeah,
property is valued at.
of course. I understand that part, but that's not what this says and not my understanding of what this was supposed to
I'm
be.
sorry about that, okay? But if what you want is us to grant you an abatement because the property is exempt, we don't have authority to do that.
I just add also again that what we're considering tonight is not the 24-25 taxation. We're looking at the petition that was filed previously was on the tax bills that you had received for the prior year.
No, he's.
Okay.
He filed an application.
Let's pause for just a second then, in terms of the presentations, and we'll get on the same page.
Okay,
So we'll do that. So
I'll kill the
set
one.
for a minute and we'll get this part figured out. The petition that I have,
Right here. This one, the new one?
8/15/24,
Okay.
seems to refer to 24 taxes.
Well, 24, 25.
Right.
Yeah. That's what he's appealing.
I thought we're looking at the prior decision concerning jurisdiction.
Well, we are, but what he didn't do was get his application in April 1st, 2024.
Right.
So he then appealed that, and we determined we didn't have jurisdiction. So he's basically come back with, as I read his property tax abatement appeal, he has checked other, he hasn't put any values in for current values. And then under 11, summary of facts upon which the appeal is based, please see attached. And then on the attached, he goes through the whole denial of his exemption request.
Okay.
And I don't, we've already determined that we did not have jurisdiction to decide an exemption appeal. So if this is an exemption appeal,
Yeah, I feel like
We-
I'm missing something here because,
we'd have to overturn our previous decision and would have to decide now.
And a part of that was based on state law
As to
and state requirements, so it isn't something the city,
That's right.
other than it's the city as being in Maine, has to follow like everybody else in Maine.
Right, and our bylaws make no reference at all to reviewing exemption decisions. Everything is abatement. And 843, which is our only jurisdictional statute, makes no mention of exemptions. Everything is valuation. If we find a property overvalued, we are to reduce it to its correct value. And that's binding on the parties, so.
well, one other thought, and I mean, we can get back to it, but, then the idea with, valuation is, right, you can't consider it an exemption. But if we're looking at, some sort of an adjustment, I mean, that doesn't seem to track with what we have, at least for tonight.
He hasn't
So
told
it's-
us, well, he
That's
doesn't
maybe where I'm
dispute-
getting a little turned
He
around.
doesn't dispute the assessor's valuations of these properties. He disputes the assessor not granting
Yeah.
an exemption because he filed his petition late, his application late.
And that does track with the, the packet and the like, so.
Right.
Okay, all right.
And he, as I understand it, just agreed that we don't have the authority to grant an exemption. Now, maybe I misunderstood what he said.
Okay, well, we can certainly continue with the presentation. I'd like to hear from the assessor as well.
Definitely.
But I'm tracking a little better now. I was
Yeah.
looking at the decision, but do you have other questions or discussion points, Mr. McGorn?
Well, no,
Are you on board? So I think this is
I'm not
just a
sure
little
where the board-
unusual.
Yeah, I mean, if we're still talking about a situation that required that material be filed prior to April 1st, and it was not, then the boat's the same boat.
Sure.
That's right.
And
We're not looking at next year's.
next year's,
Next year's is a separate matter that we had
and
discussed
I
previously.
suspect we won't be here next year with arguing the same matter, it seems like. But
Yeah,
yeah,
sounds
yeah, but I mean, I don't know whether maybe the city council can decide not to collect, I don't know. If that's even anything that the city has any control of or at all,
Superior.
based
yeah, I'm
on
not
state
sure.
law.
You can't speak for them.
No, I know that.
Right.
But that, yeah, it's, yeah, what can we
Okay.
do with X set of circumstances?
So it sounds like then we need to focus on anything that's, to add, anything that's changed, anything that's different from the prior proceeding. Is that agreeable to
Yeah.
those in attendance from both sides then?
Right.
Anything that,
Yeah.
okay,
Definitely.
okay, I'm on board then. Okay, Mr. Barty, I think we're on board and we're changing track slightly, just in the sense that we want to focus on anything that's new or different or changed from the last proceeding. And apparently we're back to more of the discussion on the abatement end of things, on the exemption side and that statute. So if you would,
Okay.
kindly continue. We are going to come back to the respondent as well,
As far as the,
given the circumstance.
Let me get the microphone on. As far as the exemption goes, I understand what the rules are and I understand what the law is. And I also do believe that you people do have the authority to make executive decisions as a Board of Appeals to certain things that go on. Now, I'll back up a little bit and I filed to get, to become a nonprofit. I turned all of the property, all of the assets of Fresh Start Inc., because Fresh Start Inc. was my company, I owned it, over to the nonprofit. Free and clear, boom, it's all belongs to the nonprofit now. And I did that because it was going to be difficult to survive without having some tax reductions. Not just property, but there's all the other stuff that goes with it. We all pay taxes, we all do. And Fresh Start, as you've read before, and I talked last time, I think you were here, weren't you? And were you here in?
I have a bit of memory issues. I don't remember being here, I may have been.
Oh, okay, so you heard my story hopefully and what
Yeah.
Fresh Start
Yeah.
does.
I've reviewed the decision anyway, so it has some.
Yeah, and what it does and why it's here and why we're here. Now, I started the process of becoming a nonprofit early in 2023. And it takes a while to, you have to file all this paperwork with the Internal Revenue Service, whatever you want to call them. And it's a long process, and I had hired a company to do it. And the company that did it, got it submitted in August 2nd, is when it was received. And as you see from the backdated record, it became a 501c3 effective August 2nd of 2023. Now, the IRS has there's nothing new here, but I want to reiterate it a little bit. The IRS has only 180 days to make a determination. And if they exceed that determination, there's no penalty for them. I received you only get a confirmation and everything is in the US mail. The abatement, the 501c3 was postmarked April 11th. It was dated March 28th, I think, I'm hoping, and but was not postmarked until April 11th. After I got it, I immediately contacted Mr. Drew here, who's, by the way, has been extremely helpful through all of this. He's directed me on what to do, and I appreciate the city's help. And in what they've done. For Fresh Start, they know that it's very, very difficult for us to survive and pay in excess of $70,000 in property taxes, and for what we do for the community. Now, so therefore, because there is no repercussion, there's nothing you can do about the IRS being late in their decision. I'm asking this board to look at, have some moral value here and look at what we're doing, and hopefully, get this fixed. I paid the first section of taxes before September 16th, so we didn't add anything on, but it also caused us to go into debt. And we can't continue that, it's very, very difficult. We have a lot of homes. We leased two properties, one from the Bangor Area Homeless Shelter. We leased one from them. They bought it strictly for Fresh Start, and one from the Bangor Recovery Network, which deals with people in recovery in Brewer. They're located in Brewer. And we leased those are the only two we leased. The rest we own. I owned 5 personally. The first 5 houses were bought under my name, and I leased them for next to nothing to Fresh Start, enough to cover the mortgages on them. But Fresh Start, because it's a triple net lease, pays the taxes. Now, they will continue to pay the taxes as long as those original 5 houses are in my name. All the houses listed here are deeded to Fresh Start, not to me personally. So, it's not like I'm not willing to pay any taxes, but I'm looking for some mercy from the board to perhaps relook at this, because it would have been submitted in time if the IRS had done their job. Now, I know you're not responsible for what the IRS does. I'm not responsible for what the IRS does, but I think I've tried to do everything that you folks have asked me to do and directed me to do from our last meeting. In the first meeting, you told me to file an abatement, and that's what I did. Now, I wasn't aware that we were going to be rehashing this. I was kind of thinking that this was going to be an abatement because the tax bills, just like it said in the letter, the tax bills hadn't come out then. So there wasn't too much we could talk about at that time. And here we are again kind of rehashing something that the board had already made a decision on. And if the board feels that they can change their mind, it would definitely be appreciated. You know, you'd be doing something very valuable to a lot of people. We have 150 residents. 35% of Fresh Start's members, we call them members, came unhoused. 28% came from incarceration, whether it's Penobscot County Jail, Penobscot Drug Court, or from the Department of Corrections. The rest of the population of Fresh Start came from local detoxes, Wellsprings Rehab, or from home. And, you know, we tried to make a difference, and I believe I've expressed why I do it, and I don't need to rehash that, you know. It's something that needs to be done, and I'm glad to do it. It gives me purpose in life, and that's what we all need, is some purpose in life. So I'm asking you for some mercy, that's all. Thank you.
Appreciate that, and I'll mention here, we'd like to hear from the respondent as well, but certainly this board does not question for a minute the impact of Fresh Start and, you know, the good works that it does for the city, for the community. Our initial question anywhere, or stumbling point, deals with jurisdiction and process more than anything. So that being said as well, we're of course not acting maybe as individuals, but as volunteers, you know, for the city, for a specific purpose. So I just wanted to put that out there. At this point,
I appreciate what you do.
yeah, well, thank you.
Thank you.
We do certainly want to hear from our respondent as well, Mr. Drew. Before we did that, were there any immediate questions for Mr. Party from the respondent side? No. Okay, well, let's proceed then.
So I think I would like to go to my submission, and I don't know if it helps clarify things, but it's
Yes, thank you.
my August 4th denial of the abatement
August 4th.
application. August 4th is exhibit, page 8, starts on 8. And
Got it.
the part I want to quote is on page 9, in the middle. So, main law under Title 36, Section 841, subsection 1, authorizes the assessors or municipal officers to grant an abatement when there is an illegality, error, or irregularity in the assessment. The statutes envision a tax assessment that is wholly void, not just imperfect. This type of abatement is less common than an abatement to correct an overvaluation. The words illegality, error, and irregularity are interchangeable. This claim would include an appeal where all of Fresh Start Incorporated's property is exempt from taxation. So for Fresh Start, their proper avenue, when they believe it's wholly exempt, is an abatement appeal. Although it's much different than most appeals on valuation. It goes to, was it basically totally in error and it should be voided?
Well, can I ask you a question?
Sure.
How can a property be exempt if they've never filed an application for exemption in accordance with a statute that's been granted by the assessor?
Right, I think that's the next question that we'd have to move to. But I think the first point is this the proper venue for Fresh Start to be asking for it to be totally voided? And I would say yes, because Fresh Start is appealing my decision to not grant an abatement, because in their abatement, they asked, essentially, we need the tax to be zero.
Well, I agree, but You state, this claim would include an appeal where all of Fresh Start Inc.'s property is exempt from taxation. Well, when the IRS issues their letter, that exempts them from federal income taxes. And maybe the state of Maine recognizes that for state income taxes. That does not make them exempt from property taxes until, as our statutes require, you file an application before April 1st and it's granted,
Yeah.
right? So why do you think all the property is exempt from taxation if they've never filed?
No, I don't. I'm just saying, I think this is the correct venue
Okay.
for that appeal to move forward. Now, we've got two different
Okay.
cases that we've had on this property, this group of properties. One was earlier on the exemption,
Right.
and this one is on the abatement of tax to zero. So they sound like they're the exact same thing, but one is just a denial of the exemption because it was filed late.
Have you ever considered yourself the Queen of Hearts? Words mean exactly what they say they mean.
That's good.
So I think that it was proper to deny the exemption request because of not being timely filed. And here, it was proper to deny the abatement request
Well,
because there's no evidence of any lower value.
then I have one other question. What has changed between the date this abatement request was filed and the date the exemption request was filed, as far as the status of Fresh Start's property?
For April 1st, 2024, nothing.
Okay, so if it wasn't exempt when he filed the first appeal, and it hasn't changed, when did it suddenly become exempt?
Oh, I don't think it did.
Right.
Okay. I guess I'm not opposed to the board finding that this proceeding is within that section of section 841 subsection 1. But then we are then going to have to decide whether the thing was timely filed. And I think we probably know the answer to that.
Well, I think at minimum, and typically we wouldn't be trying to navigate as we go, but taking a minute, as we did, Mr. Party. For the board's consideration, I think, given the circumstances, we owe it to, petitioner, also respondent, don't go too far there, Phil, but to the extent possible, one, get it right, of course, we all want to do that, but two, proceed to the extent we can where Mr. Party may, who knows what the outcome would be, but may seek additional relief if for some reason we're not able to, find favorably. So it
May I
seems,
make a motion?
you can.
I move to hear the appeal because the board does have jurisdiction under Title 36, Section 843.1 as an alleged mistake or illegality in the assessment.
Okay, well, so it's been moved then that we do hear this appeal, citing the potential for a mistake or illegality. Is there discussion? Okay, seeing none then,
Did we have a second?
we did not have a second. Do we have a second?
I have a question, I guess.
Sure. That's,
Second it, and then we'll discuss it.
Oh, that's right. I will second it for purposes of discussion.
that's seconded. Now we will discuss.
All right, I guess I'm a little confused.
You should be.
What didn't happen that should have was a request filed April 1st or before, as I understand it.
Right, and I don't know
Okay.
that
And,
part's
and,
changed, but.
and
right.
if that part hasn't changed, then where do we draw the ability to do anything with it after having found that as fact, which is what I think our first hearing did? I mean, I don't, unless there's some grant of, plenipotentiary power or ability to do something specific, I mean, I don't know how we get there.
My understanding, and throwing this out there is Dean's, you see the wheels turning and cogitating, was looking at the statement of issues, was that, one, basically, is this where the ball should land, was the first one. Do we have jurisdiction? And I think the respondent has identified in their presentation that we should. I was getting a little turned around, frankly, earlier, and still am, on an exemption and abatement, just from prior municipal experience. Those two things mean something very different to me. But anyway, so is this the place for the ball to land? And then if so, I believe the next question is, then were those applications timely filed because of 36, section 652L, which I think talks to the April 1st doomsday.
Yeah.
But I think potentially Mr. Drew, not putting words in your mouth, but what I'm getting is previously we addressed the issue of an exemption, and now apparently we're to address the issue of an abatement, which apparently are two totally different things.
Okay,
That's what I'm getting, is that,
Okay, all
in
right,
other
well,
words, there's something different about this proceeding than what there was back in June, which wasn't clear to me initially, but that's what I'm getting. Anyway, Mr. Bopan, what do you see when you look in your crystal ball?
Confusion, because, first of all, in the application, on paragraph 10, grounds for the appeal are: the assessment was fraudulent, dishonest, illegal, irregular, or in error is not checked. But having said that, I guess part of our role is to give taxpayers a formal, inexpensive review of assessor decisions. So from that perspective, that's why I made my motion.
Sure, no, and that's a great point. So that box wasn't checked, so to speak, which could be confusing.
Yes,
But I
in the
could see that.
assessor's letter, I think he cited his authority to grant an abatement, which is not section 843, I think it's 841, or
Similar.
I have to look it up, and that's the statute I meant in my motion.
Okay. No, I'm tracking, and, again, discussion, I don't mean to belabor things, but I think either way then, we proceed, I think we do have to consider, some of the dates based on.
That's the next question.
Right, based on the prior hearing, I think, City Solicitor Like was here, but had advised about the need for timely filing, and I seem to remember taking a lot of time on that. So I think we've kind of divided the question, so to speak, into multiple parts, but I think inevitably we have to look at that kind of from a jurisdictional aspect, if that makes sense. Okay. Anything else, Mr. Burgoyne, do you want to?
no, I'm listening.
Okay. Right, so moved, seconded that we proceed with the hearing, citing the assessor's letter, and that there may be something to do with the valuation being an error. I don't know about being legal, but there may be something that's changed anyway from the prior hearing. So, those in favor, please signify. I'll support it. Okay, opposed, none. So we will, take me a second to get caught up, but we will proceed tonight with the, with the hearing. Might have to order a pizza, no?
We go to the next question.
Okay, so right, okay, I'm tracking now. So we've decided then, that, we do have jurisdiction considering prior discussion, and that now we would like to move then to the second piece of this, which was looking at whether the applications for exemption then were timely filed in accordance with Title 36, the statutes annotated, Section 652 L. So as a part then of presentation, like we did before, if we would, please address this then if the board's authorities to act seems bounded by this April 1st deadline. So let's, as we did before, I think we started with the petitioner then. Mr. Vice Chair. Yeah.
The reference to 652L is actually a bit of a typo. It's not subsection L, it's the last paragraph of 652.
Okay, well, let me leave a note and made a typo. It's the last paragraph then of section
That's the
652.
paragraph that requires applications for exemption to be filed by April 1st of the year.
Got it. Silly me and my autocorrect. Okay. So we started before with the petitioner. I think we should follow the same format again, just for consistency. So Mr. Party, if you would you please address the board concerning this and this deadline?
Okay, the microphone is still on, so,
Yep.
I'll continue, I guess. Now, you've confused me. So, would you briefly tell me what we're talking about again as far as, is it dates? Because it says here, after full review of the evidence in record, I've concluded that compliance with deadlines is jurisdictional and failure of the taxpayer to comply with the applicable deadline is grounds for denial of his application for abatement. Okay?
Yeah,
So we're
we're-
talking about abatement, right? So we're talking about whether, was everything filed in
Let
time?
me
For the
read you-
abatement.
Let me read you the statute.
Yeah.
Okay. An organization or institution that desires exemption under this section, which is 652, must file a written application accompanied by written proof of entitlement for each parcel on or before the first day of April in the year in which the exemption is first requested with the assessors of the municipality in which the property would otherwise be taxable. If granted, the exemption continues in effect until the assessors determine that the organization or institution is no longer qualified. Proof of entitlement must indicate the specific basis upon which exemption is claimed.
Correct, and I understand that totally. And I'm not saying
So was your application filed by April 1st, 2020?
for the exemption, no, it was not. But that's not what we're talking about here. We're talking
No,
about,
that is what we're talking about.
we're talking about an abatement. And I believe all of that was done. And so I'm not looking to argue a point on whether that was done in time, because it obviously wasn't. It wasn't, you know. I brought it here on April 29th. It was definitely not delivered. That's not a point to even, it's not what we're talking about here. We're talking about an abatement that I was told by the city solicitor when he was here to wait until I get the tax bills and then come back. And that's why I'm here.
Okay, well, let me just ask you one more question.
Sure.
Do you dispute the individual assessment put in these properties, the value put on each property by the assessor?
I guess I would have to answer yes.
Okay, what value do you think should be on each property? And it's not zero. Every property is worth money.
$1.
$1. What do you have to support that?
I can go through this again. I'm not looking for anything but some tax mercy. Now, this is the Board of Appeals for property taxes, and all I'm looking for is some tax mercy.
Thank you.
Thank you.
Okay. Similar to, again, prior format, for the respondent, do you have any immediate questions for the petitioner?
No.
Okay, well, if you would then, would you please also address the board concerning this date and dispute and deadline and this abatement, apparently. It's not an exemption.
Thank you. Yep, it's a confusing case with multiple properties. But I think the petitioner has affirmed that the application for the initial exemption request was not timely filed. That admission, and I agree with that because it's clearly laid out in state statute, as Board Member Boping just read, that it's a hard and fast date. And at that time, I had no reason to approve an exemption as of April 1st, 2024, not for any other reason other than just not being timely filed. And clearly, that's a painful event, but it is required by the statutes. So, and then we moved on to setting an assessment on those 7 properties like we normally do, on multi-unit or single-family homes throughout the city. We believe all of their values reflect just value and are comparable to other similarly situated properties in the city. The petitioner did not file any opinion of individual market value for any of the 7 properties. There was no basis to come up with a value of 0 leading to a tax of 0. So that really wasn't going to happen. There's no evidence before the board that it
Is this a poverty abatement?
No.
Did he file for a poverty abatement? Well, you're the assessor, he'd have filed it with you, wouldn't he?
Poverty abatements don't come to the assessor.
Okay, sorry.
Didn't even know there was such a thing.
May be a potential avenue, but why don't we address that? I think that's not us anyway, but.
I guess what I was gonna ask. Do you think this board has inherent authority to dispense mercy? And if so, what is the standard that we're supposed to use to dispense mercy for relief from taxation?
This board is to dispense decisions based upon just value.
Right.
Not
in
on mercy.
the statutes.
Yeah.
Okay.
You know, the law court has made it clear that the statutes of exemption are to be strictly construed. So all doubts are weighed against exemption. So a late filing, it doesn't matter. It's weighed against exemption.
Right.
So that's really the case, is that the values reflect just value. It would be improper to grant an exemption to 0 for April 1st, 2024.
So to clarify, but the city's position would be then that, and we're not talking about, exempting taxes, we're looking at adjusting values of properties to $1 or to nothing, for example, because that does not track with or represent a just value with other similar properties within the city of Bangor. Is that?
Correct.
Okay, kind of swimming, so I just wanted to make sure I heard you correctly. Thank you. Okay. Anything further on the
No.
cities? Okay. Immediate questions from the petitioner to the respondent outside of,
No, I don't. The only thing that I wanted to talk about was when we were here the first time, and the city solicitor said, wait till you get your tax bills and come in and file for an abatement. And that's what I've done here. That's what we're looking at. We're not looking at April 1st. We've moved beyond that, and we're looking at what I was told to do by the city solicitor was to file for an abatement. And so that's what I'm here to do. And an abatement is tax mercy, because we're not arguing about the value of the property at all. You know, it's, if we were still a for-profit business, there would be no issue. You know, that wouldn't even be an issue. You know, I know what the property values are, and if I was to go and sell them, I guarantee that I'd get a lot more than what they're valued, what the tax thing is. Well, maybe not on all of them, but on most of them right today, because the values are, you know what's going on with real estate. You guys deal with it all the time. And so any type of abatement is a mercy to anybody.
Mr. Chairman, can I ask a clarification from the assessor?
you may, floor is yours to ask for clarification from the assessor.
Phil, has Fresh Start filed the paperwork necessary for you to grant an exemption on April 1st, 2025?
Yes,
Okay. So that you presumably will grant that?
yes, I've already sent,
Okay.
Fresh Start a letter that said, as of April 1st, 2025,
Okay.
they've met all the conditions to be exempt.
I just wanted to make sure that no incorrect instructions are given.
Okay, so the next part of this then, and I'm just gonna take it for a minute because I feel like from the prior proceeding, we still had some question on authority to act based on when documents were filed. The other thing, and I'll throw this out there, and this is totally outside of our court, what I'm hearing, and Ms. Barty, you're in the room, but from my experience, limited experience in municipal government, tracks with, or sounds to me like, almost like a poverty abatement. And not for an individual in this case, but for a not-for-profit. That is not this board, at least in the town that I was in. That was the full council that had to discuss that, often in executive session. There was some fact-finding and the like. I'm aware that this was filed and that we're sort of channeling this as a board to look at whether the assessment was fraudulent, dishonest, which obviously it's not, but anyway, illegal, irregular, potentially in error. We had said that even though other was checked, I mean, that was maybe the only angle that we had. I wonder if in looking at this, two things. One, I get it, it sounds like we'd like to move past the date issue. I have the statute here, I reread it. It seems pretty absolute to me. I still don't see a lot of wiggle room. It's almost like we're not supposed to touch it, but there's that. And I wonder on a poverty abatement, that's totally outside of our court, or that's not where the ball lands. But it sounds like that when we use terms like, you know, mercy, for example, or paying something, for example, in taxes, but not the full amount. I know you both also have some council or board experience, And I'm wondering what, if any, thoughts you would have, where obviously, we appreciate, Fresh Start's contributions to the community, the like, but also, I am still a little hung up on the wording of the statute in terms of when we got all this started. Anyway, looking at dates, I get it. We want to move beyond dates and the like. I'm concerned about either acting outside of authority or establishing a precedence that we don't, I don't think we even can establish as a board. So
I don't think we.
I'd like to discuss that a little bit anyway, because I think we're in unfettered waters here, gentlemen.
Well, I don't think we should do that, even if we could, which I don't believe we can. Our job is to go by our bylaws.
Yeah.
To go by the state statute. State statute's very clear. The application has to be filed by April 1st, and it wasn't. Now, there's all kinds of good reasons why it wasn't,
Right.
but we don't have the authority to change the statute. The statute doesn't have a relief valve because the IRS is late, okay? So I think we should remain focused on our job, and our job is to determine whether or not this appeal should be granted under the statute.
Given the circumstances. Okay, Mr. Burgoyne, anything?
No,
I can see
I'm
the,
back where I was before. I still,
see the wheels turning.
I mean, basically, yeah. Law is law, and the only people who can really change it is the legislature
Yeah.
with the signature of the governor. And for all the good reasons in the world. I don't know enough about the other piece and whether there's any group within the city or who could basically
Assist.
do something to say that the taxes were less or paid. I mean, I don't know the law around it, and I don't know if there's somewhere to go. But I think for the purposes of taxes and for the purpose of that tax year, I think you're as stuck as you ever were. And it's I wouldn't argue that it's fair, but I just argue that it is, and it needs to be enforced the way the legislature wrote it. And we don't have certainly authority. Whether a court might or not, I have no idea, but it just, like I said, I don't know where you go. I don't know where you go. And it would be nice if we lived in a world where government work, like what the IRS does or whatever, is funded and people care enough about it that stuff gets done timely, because it does hurt people when things don't get done timely. But I don't think we have any authority or any right to fix it, is what the sad part is.
Are we ready for a motion, or do we have further proceedings?
I mean, we didn't get closing statements, but other than that, I think we have a handle on where we're going, but let's do that. Anything further then from the petitioner, and then we'll get anything further from the respondent. I think we're tracking.
Yeah, the only thing that we're not here, I believe, we were not here to talk about April 1st. We were here to talk about the abatement that the city solicitor said that I needed to file, and I did in a timely manner. And you folks, as the Board of Appeal, does have the authority to grant Fresh Start some tax relief. You do have that ability. We're not talking about the exemption of April 1st. We're talking about reasonable accommodation and an abatement of the taxes, not April 1st, and not when, because we all know that it was filed, and for whatever reason, we know it, whatever, and I agree, the law is the law. The law is the law, absolutely. But it's my understanding, and just as I've read to you before, that this is an appeal for an abatement. And so I'm asking that you grant an abatement and you do have the authority to grant abatements, so. And an abatement is mercy to anybody that asks for it. Anybody that asks for an abatement is the city granting some relief. And that is, mercy of some sort, and that's it for me. And I thank you for your service, all of you guys have done, and I do miss Phil Cormier, he was a character.
Absolutely. Thank you. And then from the respondent again.
Nothing further from the city.
Okay.
Mr. Chairman,
Mr. Vice Chair.
I move to deny the appeal because the petitioner did not file the application for exemption on or before April 1, 2024, and he did not file evidence that shows his properties the assessments are manifestly wrong.
Okay, second. Okay, it was moved and seconded then that the board deny the petitioner's request for abatement, indicating that the applications for petition for exemption were not filed prior to April 1st, 2024, and that the petitioner did not prove that the assessment was manifestly wrong. Is there discussion? Or, sorry, is there a second? Seconded, okay, discussion. I think we had some trying to figure out where we could go on this, but I would reiterate briefly that while I remain uncomfortable with this, I think things are fairly explicit, as stated previously. I do hope there is something available anyway with the city.
Along that line, if I could request from the assessor, if he I'm really concerned that you're acting based on information that you got at a public meeting from a city employee that seems to be a long ways from.
Oh, wait a second now.
I'm not blaming anybody, I'm just saying.
The attorney was here on behalf of the assessor, not on behalf of the board. And the attorney doesn't speak for the board.
No, I know that. I know that, but I think, city officials, when they're acting in this building as city officials, I think there's something that goes with that too. That's all I'm saying, that's all I'm saying.
George, we all agree with you.
Okay, good. Then I don't need to say it, all right? No, scratch that. Okay, all right.
No, appreciate it. Okay, other discussion. Okay, seeing none, those in favor signify by raising the right hand. Down hands, those opposed. Okay, so the petition is denied. The board will prepare a written decision over the next 10 days. We'll get that out through the assessor's office to you, Mr. Party. And as stated previously, I mentioned just in discussion the potential for maybe approaching the council, where I did use the term poverty abatement, which is not something this board would even comment on, but I'm only throwing that out there from prior experience. I was in municipal government as an assistant town manager, and I did discuss that with folks occasionally. I would also mention briefly the prior decision, there is reference made to the Superior Court. We are not a law court, but I wanted to throw that out there. Potentially that's an avenue for you to get some sort of resolution for this issue. I think reiterate the board's concern that maybe this isn't for us anyway to handle. But we do very much appreciate the time. I know we went way over and participation. So we will, with that, entertain a motion to adjourn.
So moved.
Second. Okay, those in favor? Myself. We are adjourned. Thank you. Appreciate it.